Good evening, everybody. I'm Sam Shihab with the law firm of Shihab Burke, and with me,
Brian Burke, also here as well from that very same law firm.
and as I have promised you last time, we will bring Brian Burke back to the office, although he's on vacation today, to join us in our discussion today for 1 hour.
Well, I'm not
Um,
technically in the office, Sam. I'm in my office doesn't have curtains quite like this. I am at home.
those are nice curtains, but you are mentally in the office now.
There you go. Yeah.
Today, quick introduction for everybody who is not familiar with us. We are an immigration law firm out of Dublin, Ohio, practice immigration law throughout the U.S. We do employment immigration law, and we do family immigration law. And we spend an hour with the community every week for to discuss issues of concern, answer questions, and come out with a topic that we would like to kind of talk about for 10 or 15 minutes. And today's topic is overview of the modern PERM Labor Certification process. There isn't a whole lot of explanation out there on the process in a way that is, you know, easy to understand. So we try to do something that's kind of easy to understand, maybe for those who are new into the pipeline, filing these green card application, and they want to understand what the PERM Labor Certification is, Brian.
Yeah.
I'll start with the highlights and I'll turn it to you. I know you'll dive into the details. You're a very detailed person. The labor certification is an application by an employer, not by you. That's the first thing we always educate people. Say that you are not the client. You, the employee, are not the client for the application, and this is to be filed by a U.S. employer, and it's filed with the U.S. Department of Labor, not with Homeland Security. And to request,
No, totally different branch of government. Not part of Homeland Security. Not part of yeah.
and basically, in simple terms, the employer is telling the U.S. government that the Labor Department, U.S. Department of Labor, that I would like to get a green card issued for this potential employee or prospective employee or current temporary employee that I'd like to make him permanent in my company because I'm not able to find qualified U.S. workers to fill the job vacancy.
Yeah.
And you go through a process, and then once that process is concluded and it's filed in good faith, the employer, if successful, will be able to demonstrate the unavailability of the U.S. workers for the job. A certification is issued, and that's why it's called labor certification. A certification is issued, and the green card process really begins after that. So that's my 5 minutes summary or less of the process. The client is the company. The entity that pays for the attorney by law is the company. The
Yep.
employee cannot pay us for the service. Was not the case 30 years ago. Nobody cares about what happened 30 years ago except people like me. 30 years ago, we used to receive payment legally from the employee, and the employee would pay for the process, and that was acceptable. Um, then the rules have changed. I do not know what year, the magic year, 15 years ago, plus or minus, maybe a little bit more.
Maybe it was when they changed between the reduction in recruitment and the present perm system. Sam, would that be it?
Yes,
Probably
yeah,
about the year 2000. So about yeah.
about the
I,
same time,
yeah.
about that time, yeah. So, so the labor certification gone through many changes, and the Department of Labor keep trying to make it more modern every time. And there's a new change that occurred less than a year ago,
Just about a year ago.
about a year ago, for a new process, a new way of doing the same thing,
Yeah.
a new way of doing the same thing. So we went through the traditional labor certification, and it was a disaster back 30 years ago. You would go through 6 years of H-1B time, Brian, and not get a labor certification in certain states. And there was no relief to extend H-1B beyond 6 years. And laws have changed with time. People will go through a labor certification, and after 6 years, they pick up and leave. and
Yeah,
they
that,
don't
I
even
guess
get
that's
the
around
labor.
the year 2000 as well that they got the changes in the law that allowed people to extend pursuant to labor
Yeah.
certification. And
So they moved on to something called reduction in recruitment, which is kind of start taking shapes and feel of what it is right now.
yeah,
And then they came out with the perm process, and now they came out with the re-engineered perm labor certification.
yeah.
Um, Brian, I don't know. That's basically what it is. And Brian, you want to go through it in a more succinct way? There's a Joe
Me
gave
more
us.
succinct, Sam. I don't think I think I know how to be so to be so. But you know, I guess you gave us the great overview of perm, what it's all about. It's that an employer testing the U.S. job market to see if there's any U.S. worker that could fill a job they're trying to offer a foreign national as a path to immigrate to the United States. Um, Whenever I talk about the perm process, I always have to view it as sort of step one of a three-step green card process. As an aside, step one is labor certification. There's a great conversation to be had about I-140 processes don't require labor certification, but most I-140 processes are going to require perm labor certification. That's what it is. Testing the U.S. job market. Step two, filing I-140. Step three, applying for a green card, typically done on I-485, way down the road. Three-step process, but today we're talking about perm. And for me, guess I'm going to call perm itself a three-step sort of process. For me, step one of that perm is step one is to file a prevailing wage with the Department of Labor. When we start the perm process in our office, people always ask the question, Brian, do I qualify for EB2 or EB3, or which part of EB3 do I qualify for? Which part of EB2 do I qualify for? And my answer for them is something that always makes people go, "Huh, I don't get it." But the answer is whether you qualify for a category is one question, whether you have the credentials to qualify for a category, but whether you're actually going to be in that category is up to the job that's being offered to you. So, it's very possible, and believe me, I've done it before. There are people who have PhDs and master's degrees and want to be in the EB2 category, but their employer is just not offering a position for them that has that sort of qualification on it, and as a result, that person ends up in the EB3 category. So, I guess the thing I would say about the prevailing wage is it's the prevailing wage is a description of the job. I got to mention this part that your employer wants to offer you. It's what are you going to do? What are the educational requirements? What are the experience requirements? What are the skill requirements? Right? But all that is defined by your employer, not your qualifications. Obviously, that offer of employment must match your qualifications because one of the requirements for this perm process, the I-140 process, is you have to meet the requirements set forth in this prevailing wage. But the bottom line, it's not defined by what your credentials are. It's defined by what your employer's minimum requirements for that position they want to offer as your path to immigration to the United States. So if you have if they say the minimum requirement for this is a bachelor's degree and 2 years of experience, and you have a master's degree, and you're shouting at the rooftops, I want EB2, impossible. It's not with this employer anyway. It's not the
So
job.
would it be fair to say whether or not you are an EB2 or EB3 depends on how the job requirements as drafted by the employer, not as by what your personal accomplishments are.
Stated succinctly, yes.
Okay, so don't look at your achievements to decide what category you're in. Look at what your employer require for the job. And why would the employer require a lower level as opposed to a higher level? And I offer two answers for you, two potential answers, and both could be correct, or one of them could be correct. Number one, the job doesn't require the level of skills that you have achieved. If you have achieved extremely high level of proficiency in a certain area of expertise, the job may not require that. Secondly, which is more importantly, is the salary. The higher the qualification for the job, the higher the salary, and the government tells us how much to pay. The employer does not tell me, and don't tell the employer. The government tells us through a process called prevailing wage what the salary will be. And guess what? If you put high level of requirement, you're going to get high level of salary because that's how the world works. The higher the requirement, the more they have to pay
Yep.
you as an employee. So the employer wants to pay a fair fee for a first fair service for a job that he needs or she needs. They're not going to do something that's completely out of whack.
I mean,
That's not what they do.
I'll tell you a downside. I mean, maybe you were about to get to this one. The downside of doing something out of whack is that the government has their own estimation of what the normal requirements for an occupation should be. And if an employer goes, far outside the scope of what the government considers normal, the government can question that. Basically, the government can say, "Whoa, whoa, 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 whoa! You're setting your requirements very, very high for this position. Maybe we think you're not being honest about your requirements to sort of, goose the case in favor of your employee who you really want to see get a green card. You're setting the requirements so high that no U.S. worker can really meet them."
And the U.S. worker wants to help the employee. The U.S. worker would not call a lawyer and be willing to pay for a lawyer to do a process as complicated and expensive as this process unless the employer feels that there's a quality person on the other side of this equation
Yeah.
that they would like to bring on board. And they are usually gun ho. So, as gun ho as the employee normally is, the employer is equally as gun ho to say, "Oh my goodness, I want to bring this guy. The job requires so much." And we're going to say, if the job requires that much experience and talent and requirement, you're gonna have to be prepared to pay that much more money. And they will say, "Oh, that's 20% more than I'm budgeting." I
Oh
say,
yeah.
"Well, you need to reconcile between your budget and the requirements because one of them has to give."
Yeah.
And reality sets in
Yeah.
onto into where we're heading with this application.
Yeah, I mean, fundamentally though, there's when it comes to setting those requirements, another factor that goes in there is that the employer just sort of sometimes has to come in reality. Like this guy, Mr. So and so, he can do this, he can do X and Y and Z, and I showed him how to do this. And when I start asking questions about, so he got all this training, from working with your company. Yeah, suddenly that can be a problem as well. All that great experience you get with the sponsoring employer is something that is, I won't go into that aspect of the conversation, but it can be difficult to use in somebody's favor in the labor certification process because generally there's rules against that.
The
You
idea,
gained with the same employer.
yeah, the idea is if you as employer spend the time to train a foreign national to learn all these high amazing skill that you're going to use to get the green card, you should have trained the U.S. worker. The
Yeah,
Department of Labor's opinion on this,
yeah. Well,
and
you
this
can train.
and
Oh,
this,
oh, great! You gave foreign John Doe foreign national, 2 years of experience, a really great experience. You're so excited about that experience he's got. He makes you so awesome to doing the job. I think you could hire a U.S. worker and you give him that same benefit of 2 years of experience, and thereby you can't require that 2 years of experience with your company. Is the So Sam, we've barely made it out of prevailing wages, and I could probably, I always, I've been doing this long enough. So I think, my job is simple, but I'm just used to it at this point. There's so
well,
much out there.
it's fun stuff, and you and I obviously have been doing this for a very long time, and it's second nature to us.
Yeah,
But this is not the kind of process that hits people's brain from the right side. People don't get it. It's a weird process. The one thing that I mean, the number one thing that I always work with the employer to kind of educate them on is the foreign language requirement, because the very first thing they say, and this guy speaks Swahili, and my God, I need somebody to speak Swahili. Why? Because his friend speaks Swahili, and I'm go. It's not related to the job. As a matter of fact, foreign requirement is the number one trigger for an audit, which can put this case in a incredibly slow moving track. Now, there are jobs that foreign language is required. It is known fact every foreign national, not every, most foreign national have a foreign language skill. So don't use the foreign language skill to exclude a qualified U.S. worker. The U.S. Department of Labor have learned that trick 125 years ago.
yeah.
And that's not something that we will allow anybody to do because we know the results.
So
Now, a translator, if you're doing a green card for a translator,
sure,
yes. Interpreter, yes. And there are other few other jobs that you can successfully trigger a foreign language requirement, but not many. I would say 1 out of 1,000, 999 cases, jobs will
Yeah,
not require.
I think I've had, I've done more, well over 1,000 at this point. I think I've had maybe one that had a legitimate foreign language requirement on it. So there you go.
Yes, yes,
Your numbers are holding true. So Sam,
yeah, exactly.
we were I was trying to wrap up prevailing wage, and you dragged us into it again. So prevailing wage, description of the job offered, what are you going to do, experience, education, and you send that to the Department of Labor, and eventually the Department of Labor, as you alluded to earlier, will tell you what that's worth. What do you pay somebody on a permanent basis to do that job in the United States? And boy, Mr. Sam, it does take an awful long time for them to get a prevailing wage determination back to you. You are looking at almost 6 months right now, and that is about as long as I've seen it during the. Maybe it's a little bit longer, about a year ago, but 6 months to get a prevailing wage back from the Department of Labor for them to review a 6-page, I think it is, form.
Yeah, so what's this in my hand?
The number, how you're going to count out.
The number of minutes it takes to get one of these out.
Yeah,
It takes 5 minutes for the Department of Labor
yeah.
to do it. 5 minutes. It takes them 6 months to issue one.
It's really
That's ridiculous.
And you cannot file a labor certification case, PERM labor certification, without a prevailing wage from the Department of Labor. Fund attorneys, folks like us, have ways to sort of, you can use a prevailing wage multiple times. Some employers will do that. But if you need a new prevailing wage, you need 6 months to get one. There is no hack. There is no workaround. You cannot file a case without a prevailing wage from the Department of Labor. Bottom line, 6 months. I want to pick up something else you said, Sam, in terms of, climate. You talked about, getting buy-in from employers and employees, and both of them, where I think they sort of get flabbergasted by the process, is the next step: recruitment. The test of the U.S. job market to see if there are U.S. workers ready, willing, qualified, able to take the job.
I've been doing it for 30 years, Brian.
Yeah.
I'm flabbergasted today.
Well, okay, so you are right to be flabbergasted. I usually have to explain to employers that basically, yes, you have to legitimately test the U.S. job market, and the way they have you do it anymore is ridiculous because the regulations haven't been updated for 25 years, and you will have to go through that process. You will have to abide by the process. You have to give U.S. workers the maximum benefit of the doubt under this process, and usually, when we talk to employers about this, their jaw drops when they hear newspaper advertisements. I have to run newspaper advertisements for somebody.
Paper, I don't know who reads papers.
Me, about once a year, when my mother buys one around Christmas time, and I'll sit on her couch and around the holidays, and see what everybody's trying to sell us with our new Christmas money. That's really kind of it. But I'll run through the recruitment process very quickly. Here's what's going to be required for every EB2 or EB3 case, generally cases for professionals. 2 Sunday newspaper advertisements in the newspaper of general circulation in the area where the job is at. A job order with the State Department of Labor, sometimes called the State Workforce Authority. A posting notice on the wall at the worksite location where you're going to be working on a permanent basis. Beyond that, you're looking at 3 quote unquote additional recruitments from a list of 10 possible ones. And Sam, I'm gonna try to quiz myself and go through those additional recruitment options. And I know I'm gonna miss one, and somebody will maybe know it off the top of their head. You got radio and TV advertisements. You got campus placement. You got on-campus recruiting. You got job agency. You have local newspaper ad, doing pretty well here. Employer website, job search website. Employee referral program. Oh boy. Trade.
University recruit. What do you call
I
these?
covered that one. I think I covered that one. I covered on-campus recruiting and university. Oh, no, yeah. So there's 10 of them, and I don't know I can't remember what the last 2 are, because honestly, there are some really painful ones that don't come up that much. ETA 9089, Sam. I can't resist. I have to look them up and see what they are. Okay, well, the job fair. I forgot about the job fair, and I almost had this one: the trade or professional organization uh, contacting them using their services. Those are the two that I had forgotten. So, of that list of 10, so close, Sam. I didn't say the trade one because I wanted to be sure, but I digress. An employer has to choose for professional occupations 3 of those 10 to supplement the 3 we discussed that are required for every case: Sunday newspaper ads, job order, and a posting notice at the work site. So basically, what happens during the recruitment process? Your employer is going to do the 3 required recruitments for everybody and the 3 additional ones, and take resumes, take applications from U.S. workers. And it is the employer's job to vet those U.S. workers to see whether any are found that are ready, willing, qualified, and able. Realistically, that's going to involve contacting them and basically doing an interview with them and seeing if they meet the requirements. And there's here comes those competing interests again. You know, in order for your perm case to get filed, there has to be no U.S. worker found ready, willing, qualified, and able. Now, you and your employer really don't want to find a U.S. worker, but it is the obligation of your employer. And I mean, everybody wants to abide by the process, I suppose, but it is, I guess it's our job as attorneys to make sure that that process is abided by, because it's really in
In
everybody's
good
interest.
faith.
Yeah, exactly. I guess everybody's hopeful. Everybody's pursuing this process because they want to see their foreign national employee that they love get a green card, of course. But
But you got to follow the process, and it's in
yeah,
good faith, and it has to be done right. That's the only way you can succeed, by doing it right.
yeah,
And in this country, there is a serious shortage in many occupations, especially in the high skill level with engineering, technology,
yeah,
etc. And you don't have to bend the rules to get there. Just follow the rules. And if you follow the rules, work with an experienced attorney that knows how to do the perm, how to do it, how to comply with the regulations, you'll find that more often than not, you'll probably, if you have high, unique talent and skills, be able to be successful.
yeah.
So that's really the bottom line.
Let's get to the end of this process then, real quick, Sam. So
Sure.
you do the recruitment, assuming the employer finds no ready, willing, qualified, able U.S. workers. A case can move forward and be filed at the Department of Labor. One thing to note is that calculating exactly when you can file a perm case is a complicated matter, which Sam has a PhD in, and I'm a student of his tutelage. It's basically there are complex calculations to figure out when a filing window is for a perm case. The short answer is your recruitment can't be more than 180 days old. It can't be newer than 60. Essentially, you can't use it before you hit about 60 days from its inception, essentially. Long story short, you end up filing this. If you don't find any qualified U.S. workers, you file this form with the Department of Labor where you certify, here's all the work that I did. Here's our efforts to recruit. We didn't find any U.S. workers. Please, approve this case. Boy, Sam, processing times come up here again, major. One of the things you mentioned recently was the revamping of the PERM program through the creation of a new ETA 9089 form. The ETA 9089, the PERM form that the prior one was used until middle of 2023, and it was used since about 2004 with some minor changes here and there. And now they have new online portal through which the case gets filed with a brand new revamped form. And the big drum roll, we were waiting for a long time to see how long it would take to process the new cases through that portal, and the processing times have gone up. We are seeing certifications right now in September for cases filed in July last year. So we are up at about 1 year and 2 months, whereas for cases under the old form, the old system, they were at about a year and a month. So basically, the transition, as I see it, from the old form to the new form has resulted in an additional bonus month of processing time on labor certification cases.
But that can go down.
Yeah, yeah, it
That
can
can
go
go.
down. I
Yeah.
hope I hope that it is more efficient for them to process forms under the new system. I hope it's better. I wish those good folks at the Department of Labor who are doing their best all the luck in the world with it. But as a guy who's seen the times just creep up and creep up over the years,
This process is really, I think, in fairness, Um, you need an attorney to do it. And I've seen people try to do it on their own and failed miserably.
I have seen that
Um,
as well. I've helped
and
a couple
yeah,
employers who've had their cases massively audited over filing it.
yeah, and you really need an attorney that does this regularly. This is something that requires really specialized skill. There's many good lawyers out there that do it. We do it on an extensive level for our clients. We have an attorney, a partner in our office who have spent more than 30 years with extensive focus on labor certification only.
Yeah.
So has both the history and the foresight, and she always come and keep us straight. All of us have great experience in it, but we have really high level expertise. But also many other law firms
Oh,
do
yeah,
it
I've been
very well.
doing it for about closing in on 15 years myself, and
Yeah.
it's really a fun new time right now with the new form. That's
Yes.
what it is.
Let's begin taking questions, Brian.
Sure.
This is where we would like to listen to your questions and hopefully answer your questions. There's no attorney client relationship established because we're talking, and please, we don't know enough about your case to take our advice and run with it. If you hear something of an interest that really gets your attention, counsel a qualified lawyer to advise you on your case after reviewing the full facts, because we don't have the pleasure of doing that. So, Brian, let's take the first one.
Sure. So this is from Pakala Prasad. Hi Sam. Hi Brian. Hello Pakala. I've been following the show for the last couple years when I filed my I-45 in November 2020 in EB3. And there's part two. I got an RFE in August 2024, submitted it last week and got the approval last Friday. In
Whoa!
EB3, awesome. And thank you for your advice over the years. Really appreciate it. Oh, you're welcome. Congratulations, Pakala.
Wow, that's awesome. That's wonderful news.
Yeah,
Well, we haven't had any impact on the result of your case for sure. We probably had an emotional and psychological impact of you hanging in there and trying to keep things in the positive direction. Hopefully, we hope for you and your family, Bakala Prasad. I wish you the luck. Really happy
yeah.
for you. Go ahead and start living up the American dream. And you're welcome anytime on our show. But now your Monday 6 o'clock is free.
It's
What are you
free.
going to
Yeah.
do with it?
Well, I know what he should do, presuming he's a gentleman. One, read the USCIS website about preserving your green card, about what it means to be a permanent resident of the United States and how to not screw it up. Um,
Excellent point.
know that if you're so interested, in 5 years, you can apply for U.S. citizenship on Form N-400. And
4 years and 9 months, Brian.
4 years and 9 months, indeed, they allow you to apply 90 days before. Ooh, and he should also remember that he's still obligated to update his address with USCIS within 10 days of moving, because you abide by that requirement until you're a citizen of the United States.
Yep. Perfect. Good summary. All right.
Sam, your version was a lot more fun. Mine was a bit more, there's still rules for you.
Well, rules. That's how we live.
Yeah, we are lawyers, of course. Yes.
Yeah.
So, from Arindam. So, I'm a computer science and engineering graduate from India. Have 24 years of experience in software development and IT industry. Nice. I have an idea as to where this conversation is going. Area of expertise: software development, AI, machine learning, and data science. Okay. All right. Currently on EB2, priority date June 5th, 2015. On my request, my employer's attorney reviewed my profile and decided to try EB1A. It doesn't sound crazy to me. I have dabbled in I-140 EB1s for people involved in software development relating to AI. And let's see what we got here. Per attorney's documentation, I'm meeting 4 out of the 10 criteria. My question is, what is the possibility of it getting approved? Well, that one is a devil's in the details, sort of, for me, Arindam. You, I don't.
If
So
if you have 4 out of 10, we would normally say that's really positive.
Yeah.
Because USAS like to knock one out, and typically there's one that's soft, and three or four that are, two are solid and one in between. So it all comes down to how solid they are, how well documented they are. Really, it's the devil is in the detail. But I'm encouraged for you.
Yeah.
You have a lawyer that seems to know what they're doing. So yeah,
Yeah. I
that's
mean,
good stuff.
so I guess I'll point out there's sort of two requirements you have to meet. One, you have to meet three of the 10 criteria, so you're going to meet that. The other requirement is there's a totality of the circumstances test that says, looking at the big picture, is this guy somebody is of extraordinary ability? And part of that is, a little bit of showmanship from the attorney that's writing of your case to sort of tell the story of Arendum, to basically sort of sell you as a person of extraordinary ability. Um, and so that's really what's left out there. It's very possible to meet the requirements and still not get approved for EB1A if you can't be sold as something that's interesting. I would say to that end, AI is a very interesting big area right now. And I think that's the sort of thing that might interest the government. That's for sure.
Good one.
You know. Well, Sam, I'm gonna kindly ask you to address the next one.
I-45 filed with EB3 and have EB2 approved now as well. Okay, so you have, so I'm assuming I-140 EB2, right? I-45 filed, and then I have EB2 approved now. So I'm thinking this is an EB2 and I-140 for EB2. That's my understanding. Otherwise, then you have a green card if your I-45 for EB2 is approved. So for EB3, if EB3 with a priority date of February 2013 gets current in February of 2025, which is down
EB3
the road.
record for October is final action dates is in November 2012 right now, and it's already in June of 2013 for dates for filing. So
I will still be considered under EB3. All right. So before we say yes or no, let's organize this mentally, so we're all clear on what I'm answering, because it may be different than what you're asking, potentially, because obviously we have one sentence to work with. So I got an I-140 for EB3, and then the pending I-485 in EB3. Then I have an I-140 in EB2. I don't have information on whether you have an I-485. I'm assuming you don't. That's pending. I'm also assuming you haven't done any transfer underlying basis between them. So your I-485 remains with the EB3 for right now. That's basically my assumptions on your questions. Brian, do you agree with my assumptions before I go beyond?
well, I'm going to state it back just my version to make sure, because I'm.
Sure.
So there are two I-140s approved, EB2, EB3, and I'm presuming somebody has a I-45 pending based upon EB3 at this point.
Yes. So that's the assumptions. So if the EB3, which is at a 2013 priority date, gets current in February 2025, I will still be considered under EB3. Would I be considered under EB3?
No.
Well, the answer is absolutely yes, because you have an I-485 that was filed on that EB3.
Yeah,
And
there's a form saying, based upon this either concurrently filed I-140 or.
If you have not done what I would be the only thing that would screw this up is filing an I-140 amendment from the EB3 to EB2 that would kill your case. But I highly doubt that that's what happened. Extremely highly doubt, because nobody does it. Nobody does that.
Yeah.
So you have filed a new EB2 and you got a new I-140 approved, and you're wondering because I got an I-140 and EB2 approved, does that messes up anything that I have or neatly packaged in the EB3 world? And the answer is no, it does not ruin that for you. So that's my answer to this one, Brian.
Yeah, that's a fair answer. I mean, what I'm not hearing is, did this person do anything to get moved to the EB2 category? And that would be a transfer underlying basis or a new I-45.
Well, he has to be current for a transfer underlying basis. And 2013, last time I'm checking, we haven't hit 2013 for, I'm again, I'm making an assumption here, India. We're in 2012, I believe, mid 2012. right now, and late 2012, not in early 2013. So yeah,
Yeah,
there's no tub, no transfer on the line basis potentially
yeah.
could have been
There
filed.
must be a visa available. So says their policy
Just the
for.
9140 that he filed
Yeah,
probably, which he can file at any time.
yeah.
Okay.
Okay. Gonna keep it moving with a question from Daisy.
I have a question regarding a DACA recipient claiming citizenship on the I-9 and unemployment. I know I-9 most likely no one will see, but what about unemployment filing when they do an adjustment of status? Okay, so false claim to citizenship is one of the most worst things that can happen um, um, to you. What I think, what if let's explain to everybody what that does. False claim to citizenship is an immediate deportation, whether you are a and also permanent bar on getting permanent residency in the U.S. It's one of those things. Um, Now there is a very narrow exception in the law, which deals with underage. Now there are also mentally incapacitated. So somebody who is, not all up together, not very healthy, and makes feels things without consideration. Somebody who is mentally challenged, that would be an exception. But there is no real exception to somebody who is consciously doing it. Now, arguably, arguably, a retraction, a retraction can fix that. So if there's an I-9 that was completed incorrectly, you might want to go back and meet with the HR and just say, I just discovered that in my I-9 I was talking to a friend of mine. They brought that question. I just remembered I marked the wrong box. I want to fix that. So you do a retraction. Now, on the adjustment of status during the application, the likelihood of discovery is extremely low, but there is a question on the adjustment of status application that says, have you ever claimed U.S. citizenship? So what you want to do is you want to do a retraction. You want to go back there and inform them that there was an error. And then you need to consult with an attorney on how to properly complete an adjustment status application under the circumstances, because this is very serious offense, unfortunately, and you have to be very careful proceeding through it.
Now, Sam, I agree with everything you said, but here's my interesting, sort of, it doesn't make sense to me. So, if in order to pass I-9 verification, you have to produce documents, right? If you're saying you're a citizen, you have to produce a record that shows that you are a United States citizen. That could bring another aspect of this is to, you know, document fraud. Does that not sound possible?
Well, I think you've added facts because you don't have to produce. So there's a question in Section A that says, "What is your U.S. Are you a U.S. citizen?" You answer yes or no. Then you produce either document A or a
Yeah.
combination of document B and C. Document combination B and C, or document A could be an EAD card, the program authorization document. You can produce that, um, even though you mark the box
I
U.S.
get
citizen.
what you're saying. If you give documents, it's possible to answer that question as a citizen, say you're a citizen, but give documents that are identifying that aren't necessarily those that a U.S. citizen would have. I understand.
Or could even identify that you're not a citizen.
Yeah,
So creating a conflict. So that's why a retraction is
I got
potentially possible, because you can just say, listen, I marked this box, but I give them evidence that I'm not a citizen. I wasn't paying attention when I completed this box. I made a mistake. But that, whether or not they believe you, that's a battle you're going to fight. But it has to begin with retraction. You have to begin by going back. Now, the problem with the example we have here is this I-9 could be 5 years old with an employer. The other thing about I-9s, they are purgeable. They're purgeable. Meaning, what does that mean? That means the employer must destroy this I-9, and I believe the latter of two dates. One is 3 years from the date of employment, or 1 year after termination of employment, whichever latter in time. So if this deals with an I-9 that was completed with an employment that has been terminated for more than 1 year, that document is purgeable by law, meaning that it could be shredded. You can get rid of it. Why is that relevant? Because you could go back to this employer and you may not find this document altogether. It doesn't exist. And then the question is, how sure are you completed this I-9 incorrectly? So these are very complicated questions that you really need to have a good, patient, understanding lawyer that can walk through the nuances of it and see if they can position you in a spot in which you are in a defensible position. I've represented somebody in a deportation case one time who voted. He had no idea. He was married to a U.S. citizen, and he went to drop her off, and people say, "Oh, no, no, you can vote," and he didn't know he voted, and he was put in deportation.
Yeah,
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 and it's just very heartbreaking because you got his children were sitting outside. These are kids, and teenager kids were crying outside. The problem that in this case was very interesting. That not digressing too much, the prosecution in that case had a right before my case had a very contentious exchange with the judge, and the judge was so angry with him. So when we came up and we put our case forward, he made a tactical mistake and she dismissed the case just to punish him. And the guy walked.
yeah.
And yeah, I mean, you know, good luck. So these are very difficult cases, and I've seen very difficult cases where they were not successful in defending these cases.
Sam, you just reminded me of sort of a general maxim of immigration. Don't take immigration advice from somebody who's not an immigration attorney. Like literally, like once a month, I'll have a consult with somebody, or I'll talk to somebody in some capacity who says, "I got advice from somebody else who's an attorney and said, it should be fine," and they're usually wrong. I had a conversation with somebody maybe earlier probably sometime in last month. It was, hey, I got divorced, and while my citizenship application was, I got separated right before I filed my citizenship application, and I left the marital house, and then I filed for citizenship, being married to a U.S. citizen, and my divorce attorney said, "Oh, I'll be fine. I understand people get divorced." And my answer is, yeah, they do understand that people get divorced. And they also understand there's a requirement that you be living together in marital union with your spouse, for filing a citizenship application. And and I gave that person some good advice as to how they might be able to salvage the application, because they would be eligible for the 5-year basis as well. But it's the sort of thing where, you know, there's a lot of bad immigration. I've been victim of that as well, Sam. I thought immigration was easy early on. I remember when I first met you, I said, "What is it? Forms? Just forms then?" And you laughed, and the answer was no. It's not just forms. And there's so much to know, and there's a lot of bad advice going around out there.
So I will add something a little bit more controversial to that, Brian.
Yeah.
Um, what about taking advice and direction from an immigration officer?
I,
I tell you what, I am not here to bash the government, but I'm here to tell you that every once in a while, I'm sorry, consistently. I mean, I get people who are led down the wrong road with an officer over the phone, or not an officer, customer service representative over the phone, or a consultation I had a few days ago. This wonderful lady who is going nuts for her daughter, who is outside the country, traveling somewhere. She's an MD. The daughter's just going to medical school, and she said, "Yeah, my daughter's adjustment status is getting abandoned because we got advanced parole, and officer said, no, you'll get a new. I'll give you 30 days. It was an emergency. You will get a longer one after that." and she never did. And it's a long story. Bottom line, the advanced parole that was pending, it got is getting denied. Got an RFE, is getting denied, and she said we relied on the officer telling us what to do. And I said, I don't know what to tell you. I mean, they don't know the law.
Yeah.
They don't know all of it, and nobody knows all of it.
Yeah.
We are attorney.
Me either. Yeah. I'm still
Yeah,
learning. Never done
we're
it.
we're we're four attorneys in this office. Combined experience in this office in immigration law exceeds 70 years. All the attorneys' experience in this office.
Oh yeah.
Okay,
Yeah.
and all of us are learning, and nobody in this office has the attitude that I know everything, because we don't know everything, because everything changes every week, and we have to stay up to date, and we share information.
Yeah.
We work together. So yes, you got me started here on something, but let's take
No,
the
no,
next question, Brian.
it's a yeah. That's people probably want to hear their questions rather than us
Yeah.
rant. So from RK, I think they should allow employees to pay for the permanent labor certification. I imagine because a lot of the employers wait until 5 years to start the process for the same employee, apart from the time it's the same employee. Means that the employee process could have started from the second year, and they're forced now to start the process early because of DOL processing times. I know, yes, the GC backlog would be bigger, but worth it.
I
Um,
agree, but I came from a background where the beneficiary chose the client when we start practicing. When I started practicing back in the mid 1990s, Brian, all the way into whatever year in 2000, where they said, the employer must pay for it. Also, we as lawyers had to work harder to gain the client's trust. And yes, absolutely, it moved things along better. Um, the biggest concern, obviously, is the integrity of the process, where maybe the integrity of the process became into question because not every attorney does things on the up and up, and companies feel that they're exposed when you get not very common, but it happens. Some attorneys that are not doing things the right way,
yeah.
and there was a concern.
Bottom line, if the employee is driving the bus, that bus is not going to drag my metaphor out, not stopping to pick up U.S. workers on the way. They're going to where that will influence the process essentially. That if the employees, the foreign national workers are driving it, that the process won't be as honest.
I mean, the integrity of the process is more protected by forcing the employer to
Mm.
pay, unfortunately. However, the employee becomes subject to the control of the employer. But at the end of the day, the relationship is between the company. I mean, that whole U.S. immigration law is upside down. The sponsorship idea is archaic and old, and it needs to be revisited 100%. It needs to be with the employee. It cannot continue to be with the employer if you're going to create a system that's more competitive. That's my opinion.
Yeah.
This is 1970 stuff.
Yeah, I mean, the
Um,
bottom line, the process is right now driven by what employer is willing to do it, not who is the best person in their
yeah.
yeah. So, a question on a topic that's sort of near and dear to me, but maybe not one we cover much in this venue. Um, for UK-born person, is it easy to get E2? Do they have strict criteria that a person has family in the US? Is it going to cause a problem? Well, um, Ranyan is talking about E2 visas, not, say, EB2 immigrant visas. E2s are a temporary treaty-based investor visa that allows really anybody to come to the United States, start a business, and stay in the United States as long as they're managing that business and it's being successful. Um, and I'm going to sort of rearrange Ranyan's brain here real quick. For a UK-born person, UK is one of the many countries that have such a treaty with the United States that makes E2 visas available. But it's not just people born in the United Kingdom. It's anybody who's a citizen of the United Kingdom. I've done tons of E2 visas for people who are transplants to a new country. The most common ones are Canada and the United Kingdom. They become citizens. They're born elsewhere, become citizens of those countries, which do have E2 visas available, and that's their path to come to the United States on an E2 visa. So, Sam, how do you feel about family members who are already in the United States and you're trying to come to the United States on an E2 visa?
Well, depends on which family member and what status they're here in the U.S.
Yeah,
Right? Devil is in the details. Um, but in general, your question, Runyon, it dives into uh, sitting down with a lawyer and having a little bit more personal conversation about your situation and whether you are qualified to get an E2 visa based on your talent, your financial abilities, your who you are. And this is what can be done all the time to kind of guide you.
Yeah.
A general answer is no, it is not strict, but there are rules and regulations.
Yeah.
It is not difficult. Is it easy? Not easy, but it's not impossible. Honestly, it's not too bad at all, but it's a very sliding scale. Who you are, what you can do, what your capabilities, and who are these family members. These are very important details that will pivot the decision yes or no.
I can think of
Um,
the last E2 visa I did out of the UK. The person coming from the UK on an E2 visa, he partnered with his brother-in-law, who is a permanent resident, as his partner in the business. So, I presume that obviously, if this is his brother-in-law he's partnering with, I imagine his sister was in the United States as well. And that's somebody who could well, that sister could have been a U.S. citizen. I never really asked about her,
but
but
that's not a consideration, negative
yeah,
consideration.
yeah. Well, so we're dancing around it, Sam. But I guess the big worry might be if you have, a child over 21 in the United States, or a spouse.
That doesn't bother me, Brian. A child over 21 does not create immigrant intent on the E2 applicant
Yeah. Well, I guess you're
necessarily.
right. The bottom line is, yeah. If
Yeah.
I had a child over 20, I know if I would, what I would
If
tell.
you have a child over 21 and you're applying for E2 visa, you're
Yeah,
clearly demonstrating your
yeah. I'm not
lack
going
of
to the permanent.
desire,
Yeah.
lack of desire to become a permanent resident because you're applying for E2 visa. You could
I
have
can.
easily applied.
I'm
Yeah,
aware I could go get a green
yeah.
card if I wanted to through that child. Yeah, for sure. Yeah.
So no, I mean these things are very. I mean those questions. I mean we do E2 visas all the time. They're successful more than they are not. Honestly, where I found people have the biggest challenge with E2 visa is not getting the visa, Brian. It's being successful in the U.S.
Yeah. Starting
Uh,
a business is hard. Yeah.
yeah, yeah, yeah.
That's
It's hard
that's
work
yeah, that's the yeah, getting that initial E2 visa is relatively, I guess, not easy, but it's, what is an E2 visa?
within reach
It is hard.
for most people. Yeah,
An E2 visa is money plus a business plan, and you being the person where they can believe that you could actually execute on this business plan. But really, that's kind of it. If pick the name of the business, if you have experience in that business outside of the United States and you think you can do it here successfully, that's really kind of it. Yeah.
certainly. Yep.
Yeah.
All right. After Runyon, what do we
Yeah.
got?
So I think there's a repeat question there. Let me see here. A couple thank yous. Thank you, Ignacio. Ignazo. Thanks for watching. Let me see here. Here we are. Here's one. From Ranian. Have you seen anyone who abandoned I-45, got student visa or visitor visa afterwards?
I have no problem with that. I mean, it's not. I have seen it or I have not seen it. Most likely, abandonment, like children abandoning it, like the parents are the principal and the child was filed in I-45, and then abandoned. That's not going to be a problem.
Yeah,
As a
I
matter of
guess
fact, it's not. It's not the I-45, Brian. It's the underlying I-130 that creates the problem a lot of times.
yeah,
So what we have is an immigrant petition that's underlying the I-130.
yeah,
If that is still alive, that can continue to plague the family, the F1 visa, for example, or the visitor visa, if you will. But I've had people who have an approved I-140 for the parents and got an F1 visa.
yeah.
Excellent grade, great school.
Pretty common scenario, yeah.
Yeah.
I mean, the bottom line, I could make an argument that abandoning an I-485, abandoning adjustment of status, that's the antithesis of immigrant intent. If you had a legit I-485 in process and you said no, and then you came back, a year later and said I want a student visa, my answer would be, yeah, that's pretty clear that I don't intend to immigrate to the United States. If I really wanted to stay in the United States, why would I be coming here on a student visa? I had an opportunity to get a green card, you know? No.
Right, but remember, it's not the I-485; it's the underlying I-130 or I-140. If that remains active,
That could, in theory, be a reason for them to,
say no.
yeah, yeah,
And again, I've seen people get approved even with that because they're highly accomplished or they made a compelling case for the B visa or the student visa. So yeah, the answer is yes.
Yeah,
For Ryan has those big broad questions. I
yeah,
like
I
it.
like that.
Yeah.
So, from Kunal, thank you for hosting this weekly calls. My priority date is April 2013 under EB2. Any chance my date will become current in this year? I am Indian born. Well, for me, I think I'd would say they are past that on dates for filing right now, right, Sam? For
I
EB2.
don't have that memorized. I was looking at final action date.
So I have dates for filing up for India EB2. They are in January 2013 for dates for filing for India. And if you were to trust what the dates for filing are supposed to be, a forward-looking look, a forward look at where the visa bulletin is going in the next 8 to 10 months is what I believe Charles Oppenheim said in the past. I cannot say that I expect that would become current this year in EB2. However, in EB3, where your visa or your priority dates, the dates for filing are in June of 2013, I would say that's more of a possibility. Now, if you don't have an EB3 filing, if you qualified for an EB2 I-140, you would qualify for EB3. All you have to do is have a employer willing to downgrade your I-140 to the EB3 category. Not
I
downgrade,
agree
not
with
downgrade,
the
not
with
downgrade.
the, with
File
the
a new
analysis.
I-140 in the EB3 category based upon your original labor certification, which qualified you for EB2 and would naturally qualify you for EB3. Okay. Let's see here. Does I-485J need salary details? Does the salary requirement match the original 485 filing amount? I got laid off from Amazon and working in a small firm now. Took a salary dip here. Please advise. So fundamentally, hey, I'm going to maybe craft the narrative a little bit more, sometimes called making up facts. Satya got laid off from Amazon, which big giant tech company where they're paying very handsomely, I imagine, and they're probably and well, why am I making why I'm saying I'm making anything up? It's right there. It's basically my salary took a dip. Is it the same or similar occupation? And I believe there's an argument to be made that it doesn't have to be the same. There could be major changes in salary, and you can still be in the same or similar occupation. As I recall, the policy speaks to the type of business that you're in. Maybe a better hypothetical is I work for a private company and then I move to a nonprofit doing the same thing. Is it the same or similar occupation? And I just think you can make an argument. The bottom line, I guess, my short answer would be: it sounds like you have to make an argument in your favor, Satya. That's because the job you have is the job you have, and you still need a path to a green card,
Yeah,
right?
but he can change it if it's not right. So just weighing in here, 25 cents worth at 6:59 p.m. What you need here is you need to look at the job description. You have the location where you are. For example, if you're working in California and then end up working in Iowa, that changes the salary, or the dip is,
It's a great
10,
point.
10 15%. You know, you were on the higher end of the scale. Now you're on the middle end of the scale. So that analysis has to be carefully done to answer your question whether or not there's a problem, honestly. The fact that you took a dip alone does not lead me to conclude that you have a problem, but it needs to be looked at in totality to help you out.
Yeah, totality of the circumstances, I guess, is the thing that I would 100% agree
Yeah,
with. I wouldn't disagree with anything else you said, but
yeah,
that's the big takeaway there.
yeah. Back to our previous caller about projecting the visa bulletin, Brian.
Hmm.
Did you know that the EB2 India moved 561 days last year?
As of from September 23rd, 23 to where we're at right now, right?
Yeah, that's why I was looking because before I talked, I wanted to confirm. So we have been complaining a lot about this visa bulletin, but nobody took a moment to look at September to September, end of the year to end of the year.
Mhm.
And India has benefited. Not EB1. EB1 didn't move too much, 41 days only, but EB2 moved 500 days, 561 days forward. So can it move another 561 days? That's a year and a half, just about forward movement. So can it move that much? Because if it can every year, that's fantastic.
It can't. Well, again, I would remind you that it definitely can't every year, but up until December 1st, 2014, which is the furthest the final action dates have made, the crowd is thinner. Beyond, I dread what
Right.
happens. Okay,
Mm.
I'll be thrilled if we get to December 1st, 2014, because that means we'll be there, and so many people have gotten green cards. But when we get there, it's going to start moving slow
Yeah.
again, really
Yeah.
slow.
Yeah.
The sort of thing where you get a couple days for every month or a week for every month, and
Right.
that's gonna. If you want to talk about complaining about the visa bulletin, we'll start complaining about the visa bulletin at that point.
Yeah. And guess what time it is, Brian?
7:01, Sam. If we don't stop on the hour, we just have to start another hour again. That's the rules.
Yeah,
That's like
exactly. Yep. All right, guys. Thank you so much for listening to us. I hope able to give you some insight. And we're gonna talk less at the beginning, so we give you answer more questions at the end. Uh, we're just trying to balance it both ways. So come back next week. Ask your questions. We'll do the best we can to answer them. Have a great rest of the week from Shihab Park.